Oh no. Do you have Find My iPad?
Oh, I probably do.
Okay. Good. See you again. How's it going, Elmer? Yeah, so it turns out the HDMI cable here doesn't work for some reason. Oops. But because you told us all to keep track of our, to bring it on a USB port, I did.
Well, that'll be good.
And okay. So I think I'm all set. In fact, does this? Oh yeah, okay. You can use this snazzy thing.
Yeah, well, that's like one of the bonus things.
Any luck?
No. I'll try to.
You know, you can also have it make a noise from Find My iPhone. So you can think. All right, I guess we're supposed to get things started ourselves. I thought about just waiting until the entire room is filled up till standing room capacity, but I'm gonna not do that. Thank you guys so much for coming. My name is Pablo Arredondo. I'm a fellow at the Stanford Center for Legal Informatics, which spans the law school and the computer science department at Stanford, and vice president of legal research at a startup called Casetext. And I'm here to talk to you guys about a nationwide effort to crowdsource a citator, both why it's important that we do this and sort of how we've been going about it. But let's start a little bit earlier. Anybody recognize this guy? Hint, history of citators. Everyone says Frank Shepard. No, this guy is way older than Frank Shepard. This is an attorney named Simon Greenleaf. And he was an attorney in a small town called Gray, in a territory that was not yet Maine, but would one day become Maine. And he went into court, and he relied on a case that had been overturned. And I'm taking a little bit of artistic license here, but the judge slapped him all over the place, and he left the courtroom horribly embarrassed, near tears, and he said, you know, I never want to feel like this again. You know what I'm going to do? I'm going to make a list of every case I know that's been overturned. And I could check that list. There was no citator. And thus was born the modern citator, the legal citator. It wasn't born in England. It was actually born in what was one day to become Maine. So he actually published his early compilation of these entries, and this is an actual entry from the first ever sort of release of a citator. I apologize for using this kind of language in mixed company, but I go where the research takes me. And you can see the major components, right? There's the case. It actually gives you the holding, which a lot of citators don't, right? The words, thou art a pillory knave, held actionable. The negative treatment contradicted by Smith's case. And I just know at our startup we call each other pillory knaves a lot now, having learned that. Okay. This guy, who I nicknamed Sparkles, does anyone recognize this guy? This is Justice Joseph Story, the youngest Supreme Court associate ever appointed, and a fun bit of trivia, the only Supreme Court justice who was depicted by another Supreme Court justice in a movie. In Spielberg's Amistad, Justice Blackmun played him. How great is it to be Steven Spielberg, right? You want somebody to play your, this is back when the Supreme Court would literally ride around, and he rode into town and he learned about what Simon was doing, creating this list of all these overturned cases, and he rejoiced. He rejoiced that there are gentlemen of the bar willing to devote their leisure to the correction and administration of the noble science of law, right? Sort of good on you, right? And we'll revisit these two in a bit. All right, so a couple centuries later, here we are today. What's wrong with this picture? Anybody? Go ahead. They don't match, right. Westlaw and Lexis have different colored flags or symbols for this thing. And you might say, oh, Pablo, that's just one of these gotchas. You went and found one. No, I'm not the one that got them. These two are the ones that got them. If you read the work by Susan Neville Omart at Colorado and more recent work by Aaron Kirschenfeld at North Carolina, they've done really great studies really comparing these citators and showing how they don't agree with each other a lot. Right? I think something like 15% of the time there's a discrepancy, which kind of ties into the whole, as Bob Baring calls it, the Tinkerbell phenomenon. Right? If you're not up on your Peter Pan mythology, Tinkerbell is a fairy that only exists because everyone believes she's real. Well, Westlaw is only right because we all believe it's right. Right? As soon as anyone stops to look, there's a problem. So that's one of the problems with citators, is that they're not always right. But there's another problem. Sorry, whoa. They're locked behind paywalls, really expensive paywalls. And it used to be that you could shepardize a la carte. You could tell Lexis, I don't want your whole thing, I just want to shepardize, right? Or Westlaw, I just want to do key cite, but no longer. Now you have to buy the whole kit and caboodle. So there are these two sort of major issues going on, right? You have accuracy, and then you have access, right? Before going into sort of the WeCite project, though, I think it's important to sort of ask ourselves in a really sort of concrete way, what does a citator do? And if you don't mind a brief cultural detour, it's interesting how different cultures go about things. So, in America, we have the, hey, watch your step as a sign, right? I was in Beijing at the Forbidden Palace, and there, you're ordered not to fall down. They tell you, don't fall down. Yeah. So one view of the citator is that that's what it's for. It's a little flag to tell you, hey, watch out, right? But I think that that's actually dangerous. I think that if you look at the studies out there, attorneys are using it like that instead of understanding that, you can't really encapsulate a case relationship often in just a tricolor flag system, right? So I want to give you guys another use of a citator, what I think is the real use of it, which is a citator helps you prioritize what you read before you rely on a case, right? In a perfect world, you'd read everything that cited your case before you'd put it in a brief before the judge. But what if there's too many cases to read? So you need to be able to prioritize them. And what you have in free systems right now, like Google Scholar and others, is depth of treatment as a way to sort of prioritize. But I submit to you guys that that's a very crude way to rank them, because you can overturn a case just citing it once or twice. And you can refer to a case 5 times, but you're just doing it in passing without having much impact on it, right? So depth of treatment really doesn't get it done. Okay, free the law. So are you guys, how many people here are familiar with some aspect of the free the law movement and its various manifestations? Everything from the great work that Harvard and Ravel are doing, if I can speak well of a competitor startup. At Berkeley, there's a project called Court Listener. And I think that in terms of access to raw primary materials, I think that it's pretty much approaching a solved problem. If you want to read a case now, you can go get that case for free. If you want a statute, you can go to Cornell. But I don't think the law's free yet. I think that we have this veneer of it being free because we have access to it. But without a citator, is the law really free? And what I mean by that, I want the law to be free. What I mean by that is that people can go and do legal research that's competent on behalf of their clients without having to pay a dime, right? So if we have our equal justice under the law, that means that both sides need access to the tools needed to do legal research, even if one is very wealthy and one side is very poor, right? And the truth is that a citator is not like a luxury. It's not like something that's kind of neat to have. If you don't have a citator, if you don't cite check your brief, well, to paraphrase the great Allen Iverson, we're talking about malpractice, right? So I think the need for a citator is not a sort of optional thing. Until we have a citator, we don't have free law. Actually, let me open it up. Does anyone take issue with that? Does anyone think that we don't need a citator to have free legal research? Okay. So the question then is, well, how do we do it, right? Because it's a really hard thing to do. There's a reason why Shepard's was bought for $1 billion in 1980s valuation. I don't know how much that is today, right? It's not easy to do, but I think we can do it if we combine, and I apologize for this slide. I kept looking through Google Images to find something better, but this is the best I could find. Both algorithmic and human approaches. I think we need to bring both to bear and utilize them as fully as possible to do it. All right. So let's start with algorithms. Patterns. How many of you guys are familiar with Bad Law Bot? Okay, so for those who aren't, Ed Walters and the great folks at Fastcase realized that there's a certain custom dictated by the Blue Book, which is that when you cite to a case that's been overturned or vacated or abrogated, you have to include that directly in the cite, right? You have to say John versus Doe, abrogated by yada, 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 right? And because the Blue Book dictates the format, then it's amenable to harvesting algorithmically. And when I was in law school, I hated the Blue Book. When I was practicing law, I hated the Blue Book. Now that I do legal informatics, I love the Blue Book so much because the Blue Book is what gives you a fighting chance to pull out hundreds and thousands of patterns and use them. So what Ed Walters did was very simple. He said, I'm going to go pull out all of these instances, and I'm going to parse them. And thus, create citator entries out of them, right? So that when somebody is reading Ohio v. Roberts, you can tell them, hey, guess what? It was abrogated by Crawford v. Washington. In other words, you really want to read this case. This is a high priority case, this Crawford, to read before you go and rely on it, right? So without having to hire an army of editors like Westlaw has, you begin to get that sort of editorial categorization. Okay, but there's limitations to this, to the Bad Law Bot. It only does bad law. And sometimes you want other categories. What about distinguishing, right? If a case is distinguished on precisely the facts that you're dealing with, that case might as well be bad law, right? But the Blue Book doesn't dictate that you have to say John versus Doe, distinguished later by yada, yada, You only have to put the negative treatment under the Blue Book. So how do we go about getting other types of treatment algorithmically? Well, one of my projects at Stanford involves the harvesting and leveraging of explanatory parentheticals, which I think are one of the most grossly underutilized things in common law. What do I mean by explanatory parentheticals? I mean these guys. I mean the fact that judges for decades, if not centuries, have been writing concise summaries of cases and putting them in these neat little packets called parentheticals, and because the Blue Book does dictate the format of these parentheticals, you can harvest them. So that's what I did. I pulled out, and I was just teaching myself basic coding, but even my first, clumsy attempts, I pulled out like 300,000 at first. That was just that said holding. At first I said I only want ones that say holding, but then I was like, well, what about concluding? John versus Doe concluding that, or finding. And then at some point I just felt so good every time I got more that I'm like, just give me every, present participle that isn't quoting or citing. This is a word cloud showing the distributions of the present participles for about 250,000 of them. Later, last year, my colleague at Casetext, who's a PhD in data science, sort of did one of these, step aside, young man, let me show you how this works. And he harvested 2.5 million explanatory parentheticals, right? So I could go on and on about all the different uses we can do for these parentheticals, but let's just focus on the citator for a second. A lot of these parentheticals don't just describe what the case holding is. They don't just say John versus Doe holding that penguins can't fly. They summarize what one case does to another. In other words, they're citator entries. They just don't know it yet. So imagine if you were researching Terry, and you wanted to know, what cases should I read before I cite to Terry v. Ohio? You can read this, right? You see how this list would be useful? This is verbatim. This is judges' words. We did not hire an anonymous editor to write this, right? Our tax dollars paid the judges and their clerks to write these very useful summaries of how other cases have treated Terry. And unlike existing citators, you get really good stuff here, right? Like they actually get into the facts of what happened, right? Distinguishing Terry where there was a heavy makeup bag. No citator gives you that, right? You get a little yellow flag, right? And then you have to go figure out what happened yourself. So I wish we haven't fully built this yet and prototyped it. We've built sort of a proof of concept. But there are hundreds of thousands of parentheticals that are basically these types of entries. This is another case. This is the Apprendi case, just to show you it's not just Terry that it works for. Right? So again, it gives you all these useful summaries. And by the way, this is just a representative sample. There's a lot more for major cases, right? So what I think we need to do on the algorithmic side is bad law bot, which was a fantastic idea, and then bolster it with these parentheticals as much as possible. There's other patterns that I'm looking at. Like, for instance, if a sentence begins with the word unlike, followed by a case name, unlike da-da-da-da-da. So far, of the 19,000 I've harvested, I haven't been able to find one that's not a distinguishing case, right? But, we'll kind of that next level stuff, I think I want to explore more. So if we do all that all algorithmically, that's all well and good. I think we can make a lot of ground. We can get much further than we are today with a depth of treatment, and it can all be done for free because the judges already did the work for us. But we're not there yet, and this is the unfinished Brooklyn Bridge to signify how we're not done yet. There's still gaps in coverage when you use those approaches, and I think there are times where you really need a human, right? And so the question then is, can we crowdsource a citator? Okay, going back to these guys. So when Joseph Story learned that Simon Greenfield was writing this great citator list, he didn't just say, I rejoice. He also said, you know what? I know some cases that have been overturned. Why don't I send them to you? And when Simon Greenleaf published his first compendium, he actually included a note to the whole bar saying, hey guys, send them my way, a little help. So the idea of crowdsourcing a citator, I know you might think, well, here comes the guy from Palo Alto, everything's going to be crowdsourced, right? Flavor of the month. No, the idea of crowdsourcing a citator predates Silicon Valley, predates computers, predates information theory, and I think we'd agree that this guy does not look like your average rosy-eyed, startup entrepreneur, right? So, and of course it makes sense, right? Because it's something that is immensely valuable to the point of almost being needed. It's something that is Herculean to do, but it's composed of a lot of smaller tasks, right? It's just the kind of thing where crowdsourcing can be powerful. So we launched the WeCite Project. Originally, the WeCite Project, we launched it in Columbia in 2014. We didn't have a very good interface, right? It was just as you read through a case, you could click next to each site and a little menu would pop up and you could choose. We had no gamification, if you guys know about gamification, where you add all these things. And the response was not somewhere between like 0 Kelvin stillness and like crickets. It was just not a whole outpouring, right? We then rebuilt it and launched it as a school-wide contest with gamification, and I'll show you the platform in a second. But for now, just to take a look at the results. In the 2 semesters we've done it, we've had over 1,200 law students participate. from over 100 law schools, and they've created over 360,000 citator entries. They have categorized every time the Supreme Court has cited a case in the last 20 years, majority opinion, not dissent. It's been categorized, and we're now going through the appellate courts. I wish I could say, well, I knew that's what was going to happen. We were shocked. I was like, wait, what? They're really doing this. And it's incredible. We've asked students sort of, what are you doing? Why are you doing this? And some, I like to learn. I'm getting new understanding of case relationships. One told me, yeah, this is really addictive. And I was like, we're talking about creating citator entries, right? I just want to make sure that we're both, I saw some doing it in class, which I'm mixed about because it's not great, but then it's better than poker, right? We're stopping a lot of gambling addiction that might be developing. So it's gone really well in terms of the raw generation of the WeCites. And we've been expanding it. I think now we have ambassadors at 60 schools whose job it is to sort of, get things going. Professors have been incorporating it into their advanced legal research classes. At about 14 schools, we've done something called the Be Your Own Shepherd assignments. And there's a site I'll give you at the end. I wrote a paper in LRSQ about that whole pilot exercise. If you're interested in that, let me know and I can talk to you more about that. Okay, so let's take a look at the actual platform. So this is the WeCite platform. And basically, everyone goes to the same link. But when you go, everyone sees a different case relationship, right? And it asks you, how is this case O'Sullivan being treated here? It gives you full access to the text of the case, and you can jump to see all the different sites, all the references to it, right? So here, it's the parallel sites are doing it, right? You can skip if you want to, right? And it will tell you. And then you choose between one of 4 categories. Positive, referencing, distinguishing, and negative. So you might say to yourself, 4 categories, but Lexis gives you all these wonderful things like harmonizing and questioning, and aren't we losing all of that great stuff? Well, I have 2 responses to that. One is that if you read Aaron Kirschenfeld's paper, they're getting those wrong a lot when they try to tell you this exact specific thing. They're not doing a fantastic job with that. And secondly, if we go back to what is our original point of a citator, it's to help you prioritize what you read before you rely on a case. You're going to need to read pretty much everything that's not referencing. And the good news is that 90% of the sites are referencing. And by referencing, what I mean is you're sort of vanilla, you cite a principle, and then you put the case, right? With no fanfare, right? Positive is that much more rare situation where a court says something like, we applaud the reasoning of the Second Circuit and adopt it as our own, right? Or we extend the holding to cover da-da-da-da, right? And distinguishing and negative are well known, right? So this system, and frankly, it would be a lot slower for students if you had 8 different things to choose between and they had to decide, like, is this harmonizing or reconciling or something, So I submit that the 4 categories is both much more efficient in terms of doing it and actually doesn't really lead to a drop in the quality of the citator itself in terms of its functionality. So let's see here. I don't want to do one because we don't want to, so students can do it. You click one, then you click Save this WeCite, and then there's a little, hold on, bear with me. There's this little wheel here that lights up, and your points move, and I guess some part of your reptilian brain just loves the fact that you've made that happen, and you really want to finish the circle. And we give out prizes. Oh yeah, so let me show you guys the leaderboard so you know I'm not making this up here. Hold on. I mean, I guess I could have forged the leaderboard, but I didn't. You just have to trust me on that. So leaderboard, all time, schools, there they go, right? We give out prizes, not Ferraris. We give out, water bottles. We were giving out backpacks, but we were horrified to find out that they were little kid backpacks. So unless they were going to a rave or something, I don't think there was really much use for it. But we've had, it's really incredible. We had students write us on Christmas saying, you guys are out of WeCites, there's no more left to do. I'm like, okay, yeah, sorry, man, we'll get right on that. They really, we've had students tell on other students and say they're doing 2 monitors so that they can do them faster because there's a 10-second letter. No, seriously, it's getting law students, if you hit that little competitive thing on them. Anyway, so and then we have I think we have semester, and then we have week long, and then here let's look at the now when I want to do it. So the point is though is that we have this tremendous participation of students, more than I think we could have hoped, and they're doing it for different reasons. I think another reason that we've heard is, students, when you go to law school, you read these big major cases, right? You do this, we throw you into the ocean. We're like, here you go, wherever you land, you have no idea what's, suddenly you're reading a maritime case for the first time, right? Suddenly you're reading some case about something that a class you never took, and I think perhaps, they say they sort of like that sort of exposure. All right, questions up until now? Please. I mean, everything that I've said, not currently, but everything that I've said about everything applies to statutes equally. I mean, we just need to get to that, essentially. That could be very, very useful. We'd have to think about the categories for statutes a little bit more. I don't know if it's a one-to-one mapping of sort of how cases treat each other to how statutes are treated, but absolutely you would want that sort of thing. And those parentheticals that I mentioned earlier, often statutes will have them as well. 35 USC 103, blah, 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 and then it will tell you what it's doing. So we can leverage that stuff as well. Other questions or thoughts? Okay. So everything's going great, right? But the thing is, what if they're wrong, right? Oh, sorry, key points of information. All of the WeCites are going to be given to Cornell, where they'll be available for bulk download for free without restriction by anyone. The reason we chose Cornell and Tom Bruce is that way you guys know we're not screwing around when we say it, and this segues into it, we want to give them to Cornell once they've been moderated, right? And here's the problem. Moderation is a big key thing here, right? So I found this online. Which of the following is the largest, an elephant or the moon? And she has selected an elephant. That is a fail, not just a fail, that is an epic fail, right? Okay. Now, so because it's true, right? If you go to an attorney and say, guess what? This citator was created by law students trying to get flashlights. I mean, come on, right? Is that attorney really? And you could be like, but read Susan's paper. The other one has problems too. They're not going to read it. We got to think about moderation. So there's a few things that happen on it. So one is that I can't have the word fail over my head this whole time. Okay. So one thing is that we know the general breakdown of statistics to be that about 90% should be referencing, right? We've done analysis on other citators. Don't ask us how we got that data, but we did, and we did some analysis. So where we see a student like with 7 distinguishings in a row, we know that something's off, right? We call them Skittles because they're different color for each one. It shouldn't look like a pack of Skittles. They're a stream of WeCites. It should be a lot of referencing with the occasional, another one. So that lets us at a high level sort of see if somebody's off. We set up the 10-second, rule. If I see people, the most common mistake we've seen is positive when they should be doing referencing, because I think they'll say, hey, the court cited it 3 times, but yeah, but it was in passing. They happened to just mention a principle and cite to it, but they weren't extending its holding. It's not the case you would want to prioritize before you relied on the other case. And then we got law librarians involved, right? Some of you, so we have moderators here. Anybody else a WeCite moderator already? Okay, well, it's not too late. Pablo at casetext.com, you can hit me up and we'll add you. And we've built a moderation platform for the law librarians, which is you. All right. It looks a lot like the other platform, only, I'll give it a second. Every one of these little pulses when I'm doing a talk like this is like a day off my life. I know. Okay, so it's very similar, only when you arrive, it's already filled out, right? And you can see the student's name who did it. So this student, Jay Quirk at Michigan, right? And the librarian, so this is invite only. Only librarians have access to the moderation platform. And you can see what they've done. If you agree, you just click save and go to the next one. If you disagree, you change it to what you like and go to the next one. If you think they're really going crazy, you can flag them, although we haven't seen a lot of that. And and one thing I forgot to mention, when the students are creating a WeCite, they also have an explanation box if they want to elaborate. The truth is they're not doing that as much as I would like them to. But where there is elaboration, the law librarian can give them bonus points. So that's another sort of system to do that we're working it out. We have over 100 law librarians signed up, so let's go back to my current slide. So we have 100 law librarians signed up, But the inferno of WeCites that are coming in are not being moderated as fast as they need to be. This is not surprising. Law librarians have jobs, right? They are not allowed to WeCite during class, right? We actually, in the beginning, we didn't have gamification or prizes for law librarians because I was like, that's beneath them. They're going to be like, please, I do this for the love of justice. And I was like, no. We talked to them. They're like, give me the damn prizes immediately. So we're adding prizes as well. And that's something that we're sort of still developing. But the truth is right now, we haven't quite figured it out fully yet. The truth is, right? Because we have even law librarians who are very engaged and love the project and everything are like, we don't have a time. And they're like, okay, I'll do 50 or 100 even on a given day, which is awesome. But then the students have created like 17,000 that day, right? So we have to make it better. So how might we make it better? We are going to switch to a system that has 3 students per WeCite. So right now it's 1-to-1. Each student does a WeCite, goes to the next one. We're going to have each WeCite is looked at by 3 students. And then if there's a discrepancy, if they don't agree with each other, then it kicks up for moderation at a higher priority level, right? Because basically it's like, look, if you have all these students so gangbusters to do it, let's try to get the most out of them, right? So it will reduce their rate by 1/3, right? But it will mean that a lot fewer are going in for moderation. And the ones that do go for moderation are more likely to be interesting. Because the truth is, it's not a great use of law librarians' time to just click on referencing sites and say, yes, this is in fact referencing. I mean, it's just, there's a better way. Other suggestions we've heard is allowing moderators to filter by topic and by school. So if they say, I just want to look at my students because I want to see if they have problems. Or I'm really interested in environmental law, so I want to do that instead of, just random stuff. So that's another thing. And then we're looking at law firm sponsorship, and critically here, not ownership, but sponsorship. Because now that this is getting in front of thousands of law students, we're wondering, we're starting to explore, will firms just want to put their little logo on it and then help pay for more, bigger prizes for things like that, perhaps even for stipends for moderators, sort of head moderators, something like that. It would be fantastic if this was a self-sustaining, self-paying system. And the truth is that once we get it really going, if it gets enough momentum, I'd like to see it handed off from Casetext, from us, to either AALL or to a consortium of law schools, the way the Blue Book is. Because I think if this does work, it's too important a thing to be governed by a startup, by one startup, even one as great as us, And that's something actually after my talk I'd love to get your guys' thoughts on, sort of how this thing might be governed in its sort of later stages. So these are some of the things that we're looking at. And then, of course, applying our algorithms, then things we're doing will also help, right? Once we apply the bad law bot, there'll be a lot of WeCites that don't need to be created, right, or that can be checked. I did not think to put it on the slide, but another thing we also might do is have a student has to do 10 right. Like we give them 10 where we know the answers. And if they don't, until they can show that they've done the right ones correctly, they don't jump into like the live ones, right? So sort of some sort of like demonstration of competence. I will say that I found that the students did better than I thought they would, and that the discrepancy within a school is bigger than the discrepancies between the schools. In other words, there's somebody at Yale who doesn't do as good a job as somebody at Belmont, right? But then, within each school, there's a wide range as well, right? So it just seems to be how motivated are the students and sort of, how much attention are they spending. So those are some of the ideas that have, come to our mind. And I just think it's really critical to do this. If we finish this last piece, then you have free law. Because then a guy can say, Your Honor, I did competent legal research, and my client had no money, and I spent no money to do it. And right now we don't have that. We have attorneys going to public law libraries to try to shepherdize, and they get 30 minutes. Can you imagine, right? Or I think you have a lot of people out there just not doing it as much as they should, right? Or relying on depth of treatment, which means that they're probably missing a lot of cases that they did want to read beforehand. So the status quo, I think, is unacceptable. It's hard to get like 1 million-person march on Washington over this issue. So, it's really the law librarian community, I think, are the one community that will understand why this is important and how to guide it. Okay, so here are the sites for the paper. So all the Simon Greenleaf stuff, Patty Ogden has a great, really fun article about the history of citators and all of that stuff. Laura Dabney, so forgive me, I switched over to PowerPoint. What's it? Cindy, okay. Okay, cool. I switched at the last second to PowerPoint because the HDMI didn't work, so that's why that site is not there, but you can email me if you'd like it. And Aaron's paper I highly recommend, and then this is, the last one is my paper about the class exercise. So thank you guys so much. I'm finishing really early here, so we'll have lots of time for questions and discussion, and then we'll just all start moderating WeCites immediately. No, just kidding, I joke. A benefit of being at a startup is your email is your first name and then the startup name. So I'm Pablo at Casetext. If you have any questions or interesting, and signing up for moderator does not mean that you have committed to do X amount, as I've learned. So definitely don't be afraid to sign up. It just means that you'll get information about it and you'll have access. So please. Oh, well, I think I need to come immediately to your school and start help recruiting them. Yes, we have ambassadors, and it's amazing. Some of them are really good. I mean, some of them have like Castro-level charisma or something because they have all the students just WeCiting away. I don't know how they do it. We found that they definitely help increase the activity. And what I'm glad to see is that as we've expanded the number of ambassadors, we've seen the higher correlation, so it seems to work. I think we're at 60 right now. My poor colleague Catherine has to manage all of them, and I just don't know how she does it. But we'd love to have 200. I think that that's sort of the end goal. Yeah, well, email me, and I'll put you in touch with Catherine to do it. And the ambassadors are paid a small stipend, so it's, you know, I get something. So, guys, what do you think? Is this crazy? Is this quixotic? Is this doomed to fail? Is this greatest thing since sliced bread and you can't wait to join? Where are we? And I'm going to sit. We're just going to have an informal, relaxed conversation. Please go ahead.
So are we saying that?
Right.
Instead of the sort of like.
So, I mean, I'll just, it's not that I think color can't be useful in the categories, but here, let's just do, I don't know, I'll search. So when you go to a case right now, here we have citing cases, right? And you can sort by court, depth of treatment, or date. What I'd want to do is to be able to say, show me distinguishing negative and positive. I mean, really, that's what I want. In fact, I've thought about just being like, show me high priority ones, and don't even pollute my mind with what you think it is. Let me decide myself, right? But my guess is people are going to want to see negative, you know, to be able to isolate that. So I think in terms of the display, I think a traditional citator, I mean, if we do the parentheticals thing, that will also be cool because you'll see cases with the summary of like, this is what this case did to the case you're reading. You know, so basically a basic interface, I think would work for this. We're not putting them up right now because we're scared that people, if we have an incomplete citator, that people will think, oh, I don't see any negative treatment here, so this is a good case, right? So it was a hard decision to make, but we're waiting until we have a more comprehensive citator to put it all on. And then again, it will be for at Cornell, anyone can take it. We want people to take it, use it however we want, because this is a system that all the legal research startups can then use so that they can compete, right? Because when you talk to lawyers, you know, not having shepherds is a big deal, right? Not having a citator is a big deal. Right. Right, right.
The citators.
Right, so I think there's two things that I would do, and they both involve utilizing sources of information that are highly related to a case and that do discuss a case. So here, under Insights, we have the stream of all the blog posts, all the law firm client memos, right? All the stuff that apparently attorneys are looking for on Google when they start their legal research, right? Between those 100 posts, one of them mentions the Defense of Marriage Act, right? So you can actually correlate things by not just looking at the text of the case, but by looking at all of the blogs talking about the case and seeing, is there a statute that appears disproportionately, right? Not just once in passing, but 5 different posts mention that act. And then you can suggest that as a candidate and say to people, and have a human review that, right? So I think one of the problems right now is that we're not really fully leveraging all the different streams of information to work with each other. The other one is the parentheticals, right? So often the judge will summarize a case in a parenthetical using different words than the actual words in the text, right? Instead of summary judgment, it'll say Rule 56. So if you treat a case as not just its text, but also the accompanying blog posts about it, and those parentheticals that summarize it, you're much more likely to catch those relationships. But you're right, it's a really important point. And kind of why you need humans sometimes, I think.
Where are you getting all your cases?
So we get our cases from Fastcase. We have 7 million cases, all 50 states, US. It's really good that Fastcase is out there. Getting a hold of case law, especially I started doing this stuff in 2010, it's like trying to buy plutonium. Like you're like meeting people under the underpass and they're opening their trunk and being like, I've got Eastern District of Kentucky here for you. For something that's public domain, it's really shocking. But Fastcase has, and I don't know if you know about their process, they send it out to the Philippines, it gets typed up in triplicate, and then it comes back, and then Ed sells it to all the little startups.
So if I'm searching
Yeah, but
am I searching all the fast cases?
Oh, no, we buy it all ourselves. We have it all ourselves.
Okay.
So, yeah, and so if you do a search for an asterisk, you'll see all of our coverage for each jurisdiction. So,
And then you built, obviously.
oh, no, we built that ourselves.
So.
Yeah, no, we have data scientists that do it, and they're constantly screaming about it. And it's really fun to watch engineers learn about law, and they're like, wait, how do you guys do it? And we're like, oh, we do it like that. And they're like, so wait, different cases can have the same site? And we're like, yeah, why would that be a problem? And they're like, that's the most horrible idea ever. They're like, wait, a pin site is a whole page? I'm like, yeah, it's like a bowling pin. It's not like, it's like a bigger pin, so. Yeah, so it's a huge pain. It's hellish. But when you have it going, that's all the more reason. And I think this is what I'd love is that the startups can do that, the tech, we can do the tech, and then we need the law students and the law librarians to handle the analysis, really, right? So I'll get to you, but did you have others? You said.
I have so many questions. So
Please. Good, because I finished way too early, so.
text, resource, yes. Processes, are you like
Right.
trying to do this?
Yes, right. So we started Supreme Court going back 20 years, and now we're going through appellate court by appellate court federal. At some point, though, I think the question then is when do we switch to just updating it, right? Because a citator is only good if you update it, right? Because your case could have been overturned yesterday, right? So right now we're kind of doing this backlog. I don't know if backlog's the right word, but we're basically going back 20 years. We did some analysis to see how brief cite to cases, and there's a pretty steep drop off, right? Especially for appellate and district court. So we think going back 20 years should be sufficient, not fully comprehensive, right? But, workable.
But you're not getting to
So, I think at this current rate, I think we'll be done with the federal appellate within the next semester. Although, again, if we switch to the 3 doing each one, it also depends, do we have 200 ambassadors? Really, it's like, how much does the law librarian community embrace this? Because I really think it lives or dies on whether or not it's sort of adopted as like, we all want to do this, and then it can work. It's like any crowdsourcing system. But there's no reason we can't get to states like this year or next year. And in fact, if there are schools that are like, we only want to do it for Oklahoma, right, or something, if you have that sort of desire, I think we might want to enable that. We might want people to be able to say, I want to take on this area. But it's an important question. Definitely send us everything. Send us everything you have. That's a great idea. Oh, wait, no. Is that not what you were asking? So, yeah.
Citation or like how
Yeah.
to get the buy-in.
Wait, so by citation, you mean the code that will go and find these links and edges between cases? I personally would have no problem doing that. I think we'd have to talk. I mean, enough time has been spent on that code. However, Court Listener at Berkeley is all open source. And those guys are no dummies. And they have also created a citation map for a lot of this stuff. So I would highly recommend a guy named Mike Listener. That's probably your best bet to quickly get a hold of a citation code. But again, you know, the Blue Book really helps. The Blue Book tells you this is how these sites appear, and then you can into short names and stuff. We're going to come back to you. I want every one of your questions answered, but we'll give you a chance. Oasis? Is it Oasis? Yeah.
Oh, that's the.
Right. Well, I think overall it's a very good thing if we can move from a proprietary citation system. I mean, right now we all have to wait for Westlaw to put it out. Then we have to, those books have to be ripped apart, sent to the Philippines. And then recently, I don't know if you guys saw this, where Westlaw said, hey, we screwed up. We accidentally didn't include a bunch of things. Well, that screw up reverberated throughout everybody, right? All the other little companies trying to do it had to deal with this, and we don't have the resources that Westlaw has necessarily to as quickly do it. And as long as there is a system in place, you know, then the computer science works, right? All you need is a reliable pattern that's determined. Would it be, you will have to have two now. You'd have to have one whenever this kicks in. But I think the overall benefit of that system would be well worth it to do it. Back to you, Mariah.
No,
That's everything, all right. How many people here teach advanced legal research? Okay, so maybe I'll talk just a little bit about the advanced legal research exercise. So we've done a few different variations on that. We had one where each student looked at their own relationship and categorized it. This was before the WeCite platform was invented, right? I would hand select deep treatment ones and give it to it. We had one where at CUNY we had 97 students all look at one really complex relationship, and then we used SurveyMonkey to vote. As I hoped, there was disagreement among the class, right? Like 47% were like negative and 36% said distinguishing. 5% said positive. I think they just wanted to go home because there was no way that this thing was positive. But where the lesson I think has its most value is where the students are disagreeing with each other. Because then you see this is a subjective call, right? Just like in Westlaw, there are some editors in a room deciding what they're going to call it, and reasonable minds can disagree. That's, I think, what is really useful to capture for the students. I think everyone knows that, no, everyone knows. I think it's a well-documented problem of getting students to not just look at the flag and say, I'm moving on. And I think the current status quo is you say to the students, don't do this, and you show them an example. You're like, look, if you did it here, you'd mess up. I don't know if this is called flipping. I don't know what the teaching, I'm not up on pedagogical terms, but this is like a more learn by doing, like really diving in yourself and experiencing firsthand the challenge and the compromise inherent in trying to stuff a case relationship into just one box. The final variation is we just have students use the WeCite platform to do like 5 or 10, and then to talk about which ones if they had trouble with one or something like that. If you guys are interested in bringing that assignment to your class, in any of those variations, please let me know, and we're happy to facilitate it. All right, guys. Well, thank you so much for having me. That's my song and dance. And again, Pablo@casetext.com if you guys have any questions or if you'd like to join as moderators. You're all invited to check it out. Thank you.
Yeah. I worked with Patty often, but she wrote that.
Oh,
As a
you
matter
do?
of fact, yeah.
Okay, now where is she still?
She's I'm retired.
Okay, because I've written her these like long thank you emails, but I haven't
Yeah.
heard back, and I don't know if like, okay.
Yeah, she retired about 4 years ago, quite early actually. She was still like 59 or 60.
Okay.
She retired.
Okay.
Back. She wrote that article actually probably right mid-90s,
Yeah,
mid to late
yeah.
90s, yeah. But one thing I've always been interested in, I try to tell my students, and I don't know how, there are things that sometimes you have to go beyond just citation. Look at the list of citing, like the cases that were original case,
Right.
one you're concentrating on.
Right.
The cases it cited, and you follow those through, sometimes you may find those have been treated negatively, but yours was,
Exactly,
because
yeah.
they just didn't cite to them.
Yours is one of a little sample
Right.
of which all of them have been overturned, but only one was mentioned. Yeah,
Right,
that's a
right.
real question. And that's where I think using the secondary analysis directly,
Yeah,
right,
yeah,
because
that makes
hopefully blog posts and library
Right.
articles will catch that. And I think it's just a matter of really fusing those together in a seamless way.
Yeah.
I think right now, this attorney Googles and kind of reads some posts to get the high level, then he jumps into the case law,
Mm-hmm.
but are they really taking advantage of both simultaneously? I don't think so.
Right.
So.
What you covered so far, which has been criticized, it's never, the U.S. Supreme Court has never lower courts because they see it. But I always have students work with that and say, still rely upon this case. And you can make arguments both ways because that case with your later.
So that's really interesting because one of the variations of the assignment is we started with a big case like Plessy v. Ferguson, and each student looked at a different case that talked about it. And in theory, collectively as a group, you could then decide, are we all going to rely on this given what everyone said? But I think it's a little harder to do that if each person's only seen their one little thing. So one question is start with a case and say read everything, and then you write a citator entry for this, including like a sentence description.
Yeah.
Right? And then they might get at that. Well, it's kind of this and kind of that. And that's what you want. You want them saying, I don't really know.
Right.
Because then when they see the citator flag, they're going to go, this guy doesn't know either. Right?
Yeah, whenever I give that assignment and we discuss that in class, there's always a big split on whether people think, yeah, you can still use this or no, you wouldn't.
Okay, so there you go. I mean, that's what you want.
It's a good example.
Yeah. What, I'm curious, what does Westlaw or Lexis, do they yellow flag it like everything else that's complicated? Or do
They do actually, I'm trying to remember, I think they or whatever.
yeah, they've expanded it, the number
Yeah.
of amendments. Yeah. But yeah, I mean.
But I'd love to be involved.
Okay, absolutely.
with
So,
this.
so I do you have a card? Let me.
Yeah.
Somewhere in here. The worst conference goer ever. Okay, here we go.
Even to 1L, so we have there's a required 1L legal research. Basically, tries to convince them to rely upon those symbols as a true indicator of what here are the things that can happen. And even
Yeah, it's a real, those citator flags, they're really useful if used correctly, which is to kind of just give you a slight alert to
Right.
then look into something. But it's midnight and the associate hasn't slept in a day and a half,
Yeah,
and he's
right.
like, you know what, I'm not going to go down that red
No.
flag hole,
Yeah,
you know.
exactly.
But yes, so I'll reach out to you and let you know, and yeah, that'd be really cool.
Thanks a lot.
Cheers.
Nathan Collins from Belmont.
Oh yes, hey, good to see you, man. How are you?
Yeah, good.
Yeah, Belmont, man, you guys are the champions of WeCiting, man.
They're on
That's
fire, aren't they?
yeah, absolutely.
Will Blackburn student ambassador.
Okay.
A lot of energy.
Yeah, no, we've been like, wow, you guys really blew it away.
Yeah, it's good. I'm looking forward to.
Yes, that's right, that's right, absolutely.
So I'm looking forward to that.
Okay, cool, yeah, I really liked it. Unfortunately, I have to fly to San Diego for the ICALE, have you heard of this? It's like International Conference of Artificial Intelligence and Law. I don't, no idea. These guys are so above my pay grade. I don't know how I got invited to this thing, but, but yeah, let's definitely touch base soon about that. That's really cool.
Yeah,
All right, cool. Hi, how do you
Somebody else.
Yeah, seriously, no, you guys are the original, the absolute, the best.
Legal informatics, and why do you do this?
No, yeah, their faces, right, yeah. Oh, and I'm like, oh, parallel citations? Let me tell you about this. And I'm like, wait, what? I'm like,
Why is this like this? Okay. Work with this, and then something else comes up.
I'm like, just imagine if no one had ever upgraded anything since like the 60s. That's how far back our thing goes. So are you working on the
Yeah, not directly.
small group of people that understands what bulk means, how important bulk is,
Yes.
but bulk is the best. You
Bulk
need the
is the
bulk.
best.
Yeah.
So I will be looking forward.
Yes, we will. I mean, we got to get the moderation thing going. Not pulling out on you, believe me. I just don't want to.
Yes.
That's so good.
But I'm thinking, if they would do that much work.
Oh, the wheel! I want to make the wheel. It's like Vegas,